You're suing a doctor you once trusted for medical malpractice, and now you go to a second doctor. But you're really concerned that if you tell the second doctor about your lawsuit against your first doctor, your second doctor is going to have a problem treating you, and you don't want to let him know. Come join me as I share with you why not telling your second doctor will create a problem for you later on down the road. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So now you believe a doctor violated the basic standards of medical care, and as a result you suffered significant injury, and you actively go ahead and start a lawsuit against doctor number one. You then go to doctor number two for ongoing medical care and treatment to try and correct the problem. But you're hesitant, you're afraid. You don't want to tell doctor number two that you're in the middle of suing doctor number one. Let me share with you why that's a bad idea. At some point during the course of your lawsuit, doctor number two is going to get a letter from a defense lawyer saying, hey, we represent doctor number one, and we are now going ahead and requesting copies of your medical records. Please turn them over to us. And now doctor number two is going to look at this, and he's going to know immediately that doctor number one was sued. Maybe he knows doctor one, maybe he doesn't. Whatever the point is, he's going to get an attorney's letter requesting copies of your records. And by law, he has to turn over copies of your records because you will have signed a document known as an authorization, which allows the doctor to go ahead and give copies of your records to anyone who has that. Now, why is that done? It's part of the discovery process. So when you bring a lawsuit, your medical condition, which is an issue, now is open to the defense. And as part of the defense's investigation, they are legally entitled to get copies of all of your medical records from all of your treating providers. So one of the first things that doctor number two is going to see is a letter from the attorney saying, hey, we represent doctor number one in a lawsuit that your patient brought against our client, and now we'd like copies of her records. And now the doctor's going to know. So that's why I say it may not be the best idea to withhold that information from doctor number two. Instead, the better practice may be that when you go ahead and visit doctor number two, you may simply tell him, listen, I brought a lawsuit against doctor number one. I want to know, is that okay with you? Are you still okay treating me for my problem? Yes or no? This way the doctor won't be surprised when he gets that letter. And now later on during the course of your lawsuit, the doctor won't be surprised if he gets a subpoena to come into court and testify on behalf of the defense. Isn't that interesting? So why do I share this quick tidbit of information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice case here in New York. You know, I recognize and I acknowledge you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.